Usually when you hear a story about someone like standing up for their rights at work, it follows this very familiar, almost Hollywood-style script.
Oh, totally. The classic underdog story.
Right. There's a grievance, there's this brave stand against management, maybe a tense legal battle, and then, a vindicating victory.
Yeah.
The gavel comes down, the employee gets a massive check, the oppressive boss is publicly shamed, and justice is served. It's a really deeply satisfying narrative.
It is. I mean, we gravitate toward that narrative because it feels clean, It gives us a sense of moral order.
Yeah, exactly.
Like this idea that if you are wronged, the system will eventually recognize your pain and make you whole. But the actual machinery of employment law is completely indifferent to our need for a satisfying story.
Yeah. Which brings us to what we're looking at today. Because this landscape is incredibly high stakes, deeply complex, and honestly a little terrifying.
Highly terrifying, I'd say.
Right. It's a world where having a completely valid, morally righteous grievance on day one does not guarantee you won't be completely bankrupt by day 1,000.
Exactly, because the legal system is not just a mechanism for finding truth. I mean, it's a mechanism that rigidly enforces rules.
Yeah.
If you step into that arena armed only with the belief that you are, right, without a flawless grasp of the procedures, you are basically walking into a buzzsaw.
So, welcome to today's deep dive. We are exploring the intensely complex world of workplace disputes in Australia.
And it is a labyrinth.
It really is. And to navigate this for you, we are drawing on a stack of case studies from the Australian Workplace Discrimination Representatives, or AWDR.
Right. They're a leading non-lawyer workplace relations firm.
Yeah, they've been operating for over 30 years, available 204/7, and they've provided some really detailed behind-the-scenes looks at recent, truly dramatic employment law battles.
Some really wild cases in here.
Yeah. So our mission today is to extract the vital lessons on how these workplace protections function in reality, uncover the hidden dangers of the legal system, and understand why pragmatic strategy and self-awareness are just as crucial as the actual facts of your case.
Absolutely.
Okay, let's unpack this. What happens when a multi-million-dollar victory in court suddenly turns into a multi-million-dollar debt?
I mean, it is a staggering reversal to even contemplate. Just mind-blowing.
Seriously.
But to understand how a massive victory can morph into total financial ruin, we first have to understand the baseline, right? We need to look at what rights employees actually possess in this system, and just as importantly, who is helping them navigate the minefield.
Because nobody is born knowing the intricacies of the Fair Work Act.
No, definitely not.
Reading through these materials, it's clear the scope of workplace protections is vast. I mean, we are talking about unfair dismissal, general protections disputes, sexual harassment, toxic workplaces, non-genuine redundancy, serious misconduct. The protections are definitely on the books.
They are.
But a recurring theme from AWDR is that employees are very often completely unaware of how those rights actually function under the Fair Work Act and equal opportunity laws.
Yeah, and that lack of awareness is the fundamental vulnerability.
Right.
The laws absolutely exist to protect workers, but the execution of a claim under those laws is unbelievably rigid.
How so?
Well, you have to follow strict procedural fairness. You have to hit these crazy, strict filing deadlines. Sometimes you only have 21 days from the moment of dismissal to file your paperwork.
Wow, 21 days.
Yeah, miss that by 24 hours, and your case might be dead on arrival.
That's brutal. And it isn't just about timing either. It's about classification, right?
Yeah.
You have to know exactly which type of claim to file.
Oh, absolutely. If you file an unfair dismissal claim because you feel the termination was harsh, but you really should have filed a general protections claim because the real issue was retaliation for a workplace complaint.
Yeah.
You can tank your entire case before it even begins. The court isn't going to fix your paperwork for you.
Wow. Trying to navigate this alone sounds less like seeking justice and more like, trying to fly a commercial jet through highly restricted airspace with zero training.
That's a great way to put it.
Like walking into a high-stakes casino where the employer, knows all the odds, and you don't even know the rules of the game.
Exactly.
You're running on raw emotion, feeling deeply wronged by your employer, but raw emotion does not translate into the exact inputs the legal system demands, which is why specialists are needed to translate human feelings into a real-life, executable strategy.
What's fascinating here is the distinct role these specialists play compared to traditional lawyers.
Oh, right.
Yeah, the focus shifts entirely away from brute force litigation. Instead, the emphasis moves towards strategy, mediation, and arbitration.
So they're trying to solve the problem before it escalates into a decade-long court battle.
Exactly, because a lawyer's primary arena is the courtroom, where things get incredibly expensive, incredibly fast.
Right, the meter is always running.
Always. But a workplace relations specialist's arena is the negotiation table. They are looking for the quickest, most commercially viable resolution, because relying solely on litigation without flawless procedural awareness is just a massive gamble.
This is the ultimate gamble. And I think that perfectly sets up our first case study. We are moving from the theory of how this system is supposed to work into a harrowing real-world example of how the system fiercely punishes poor strategy.
Yeah, this one is tough.
This one is a jaw-dropper. If having objective guidance is crucial, here is what happens when a claimant loses perspective entirely. Let's look at the 2026 conclusion to the monumental case of Roohizadegan versus Technology One.
Oh, man. This specific case has sent shockwaves through the Australian employment landscape.
I bet.
It basically stands as the ultimate cautionary tale about the dangers of hubris in the legal system.
Okay, let me set the scene for you. Mr. Roohizadegan was the Victorian regional manager for a major software company called Technology One, and for a significant period, he was an absolute superstar for them.
He really was.
Yeah, he took their regional license fee revenue from $1.3 million up to an impressive $10 million.
Which is huge growth.
Massive.
Yeah.
But some management changes happened around 2014, revenue stagnated, the relationship fractured, and eventually, in May 2016, he was fired.
Right. And following his termination, he filed a Fair Work General Protections claim.
Okay.
He alleged that he wasn't fired for performance issues. Instead, he claimed retaliation.
Got it.
He argued he was dismissed because he exercised his workplace rights by making bullying complaints against senior leadership. Furthermore, he claimed he faced adverse action due to discrimination based on mental disabilities, specifically citing severe stress, anxiety, and depression caused by the toxic environment.
So he takes this to court, and initially he wins. And we're not talking about a minor symbolic win.
No, not at all.
In October 2020, the federal court awarded him a record-breaking $5.2 million payout. The court found that Technology One and its CEO had indeed committed unlawful adverse action.
Yeah, $5.2 million. But to understand why he won that first trial so decisively, we really have to dig into a powerful mechanism in employment law called the reverse onus of proof.
Okay, let's break that down.
So normally in law, he who alleges must prove, right, if I claim you breached a contract, I have to bring the evidence.
Right.
But in a general protections claim under the Fair Work Act, it flips.
Which makes sense because the employer holds all the cards. They have
Yeah.
the HR files, the internal emails, the performance reviews.
Exactly. The law recognizes that information asymmetry. So if an employee alleges they were fired for a prohibited reason, like making a complaint about bullying, the burden is not on the employee to prove that was the exact reason.
Oh, wow.
Yeah. The employer has to prove with concrete evidence that the complaint was not a substantial and operative reason for the dismissal.
That is an incredible shield for the employee. And in that first trial, the judge ruled that Technology One failed to meet that burden. They couldn't sufficiently prove the complaints weren't a factor in the firing. So Mr. Roohizadegan is awarded over $5 million for the loss of his high-earning career and the mental health breakdown he suffered.
Right. And you can imagine the absolute validation he must have felt.
Oh, totally.
But the company appealed the decision. And in 2021, the full federal court looked at the mechanics of that first trial and found major legal errors in how the original judge applied the law.
Wait, really? What did they get wrong?
Well, the full court basically said the original judge didn't properly connect the dots. Just because the CEO knew about the bullying complaints, it didn't automatically mean that was the driving reason for the firing.
Okay, that tracks.
Yeah. The appellate court noted that the original judge largely ignored the company's extensive evidence regarding the manager's poor performance, so they threw out the verdict and ordered a retrial.
Wow, and this is the moment the narrative completely inverts. The retrial runs from 2024 to 2025. This time, the court focuses heavily on the objective business realities. Technology One's Victorian region had seen zero growth for 3 consecutive years.
Zero.
Yeah. Furthermore, the court scrutinized the interpersonal dynamics and found the manager demonstrated a, quote, persistent inability to accept decisions from senior management.
Yeah, and the judge's language in the retrial was absolutely brutal.
It was harsh.
They didn't just disagree with him, they dismantled his credibility. The judge labeled him a fabulist who told transparent lies on the witness stand.
Calling someone a fabulist in a legal ruling is intense.
It's devastating, and medical experts testified that instead of severe depression caused by the company's bullying, he actually exhibited obsessive-compulsive personality traits and used his work as a destructive diversion.
So the facts were utterly devastating to his case. Oh, but the truly fatal error, like the specific decision that sealed his financial fate for the rest of his life, happened behind the scenes during this retrial.
Yeah, this part is hard to even fathom.
In April 2025, his legal team went to Technology One and demanded an unbelievable $30 million to settle the case.
$30 million.
Keep in mind, the original record-breaking win was only $5 million.
Right.
On the exact same day, the company countered with a $2.2 million offer. The terms were simple. Take the $2.2 million, both sides walk away, and everyone pays their own legal costs.
Which is a very reasonable commercial offer.
Very reasonable. But the claimant rejected the offer. He wanted his total victory.
And Technology One rejected his $30 million demand because they were finally confident in their evidence.
Right.
When the retrial concluded in December 2025, the court ruled entirely in favor of the employer. They successfully discharged that reverse onus of proof.
So they proved it was about performance.
Exactly. The dismissal was ruled lawful, based purely on well-documented poor performance and insubordination.
Wow. So he loses the $5.2 million. The vindication is gone. But the trapdoor opens even further, doesn't it?
It sure does.
Technology One and its founder spent over $10 million defending this case across 10 years of litigation. They asked the court to make Mr. Roohizadegan pay their massive legal bills.
Yep.
And the court agreed. The ruling stated his rejection of the $2.2 million settlement offer was unreasonable because the inherent weakness of his case was objectively clear.
The court essentially declared that a rational person in his position should have known the case was collapsing.
Okay, wait. I have to push back on the court's logic here.
Okay, go ahead.
If he won $5.2 million in the very first trial, isn't it entirely logical that he believed he would win again? How can the legal system punish a man for believing in a case that a federal judge had already completely agreed with once? Like, if a judge tells me I'm right, I'm going to internalize that I am right.
I mean, I hear you. It is a profoundly human reaction to anchor your beliefs to that first victory. But the legal system does not operate on human sentiment. It operates on shifting evidentiary landscapes.
Mm-hmm.
If we connect this to the bigger picture, the full court ordering a retrial based specifically on legal errors regarding his poor performance was a massive flashing red flag.
The court was broadcasting that the foundation of his first win was flawed.
Exactly. The court explicitly stated that the retrial represented a seismic shift in the litigation risk. Courts expect claimants to engage in what they call mature reflection.
Mature reflection.
Yes, you cannot blindly ride the momentum of a previous victory when the foundation of that victory has been legally dismantled. Once the new evidence regarding his performance and medical history was presented, it became objectively clear that a finding of adverse action was no longer highly likely.
So the writing was on the wall.
Absolutely. Continuing to demand a $30 million fantasy settlement instead of accepting a commercial compromise is viewed by the court as obstinate, vexatious conduct.
It is just staggering to conceptualize. I mean, he had a concrete offer to walk away with $2.2 million.
Which is life-changing money.
Life-changing. And because he held on to this idea of total crushing victory against his former bosses, he ended up walking away with nothing and inheriting the $10 million legal bill of the very company that fired him.
It perfectly illustrates why specialized, dispassionate guidance is so critical.
Yeah.
A good strategist looks at the shifting odds, ignores the emotional desire for vengeance, and tells you when it is time to cash out your chips and leave the table.
So the devastation in that case came from an utter refusal to accept a reasonable exit. But the system is equally brutal if you try to play games with an exit you have already agreed to.
Oh, yeah.
Let's look at the flip side of this coin. What happens when an employee does accept a settlement, signs on the dotted line, takes the money, and then years later tries to rewind the clock and come back for more?
Yes. You are referring to the 2025 Supreme Court of Queensland case, Baughit versus Hartley-Healy.
That's the one.
While Roohizadegan was about the failure to settle, this case deals with the absolute uncompromising permanence of legal agreements once a settlement is actually reached.
All right, here's the background for you. Miss Piquet worked for a Brisbane law firm. She alleged she was sexually harassed by a solicitor there between late 2015 and early 2016.
Okay.
She lodged a complaint with the Human Rights Commission. They went to conciliation, and in April 2017, they reached a settlement. The firm paid her $30,000. They converted her termination into a resignation to protect her resume, and in exchange, she signed a deed of release, protecting the firm from any future claims.
It was a very standard non-disclosure and release agreement, but crucially, the deed explicitly stated she could not pursue statutory benefits under Queensland's Workers' Compensation and Rehabilitation Act.
The WCR Act.
Right, often referred to as the WCR Act.
So she takes the $30,000, leaves the firm, and the case is closed. Or so the firm thought.
Right.
Fast forward 4 years later, in 2021, she reopens a battle. She sues the law firm in the Supreme Court for breach of contract and negligence, basing the new lawsuit on the exact same original harassment allegations from 2016.
And her legal justification for bringing this new lawsuit was highly technical.
How so?
Well, she argued that under the state's workers' compensation laws, the ability to sue your boss for negligence is heavily regulated by the statute. Therefore, she claimed, this new lawsuit actually qualified as a statutory benefit under the WCR Act.
Okay, here's where it gets really interesting. In Queensland, the law says you cannot legally sign away your statutory benefits. Any contract that tries to force you to do so is just void.
Right.
So her argument was, suing you is a statutory benefit. Therefore, that settlement deed I signed back in 2017 where I promised not to sue you is legally invalid. I'm keeping the $30,000 and I'm taking you to court anyway.
That's a bold move. And the employer obviously fought back aggressively. They argued she was trying to double dip, take the settlement money to resolve the issue and then litigate the exact same issue anyway.
Which you can't really do.
No. And the firm pointed directly to the indemnity clause contained within the deed she signed.
Right. Let's clarify what an indemnity clause actually does, because it sounds like generic legal jargon, but it is actually a financial trapdoor.
It really is.
An indemnity clause is a promise that if you break the rules of the contract and cause the other party to suffer a loss, like, having to hire lawyers to defend a lawsuit you promised not to file, you have to personally reimburse them for that loss.
It shifts the financial risk entirely onto the person who breaches the agreement.
Yeah. It's like signing a settlement deed with an indemnity clause is like sealing a heavy, watertight hatch on a submarine.
Okay, I like this analogy.
Once you turn that wheel, you are safe. The water stays outside.
Yeah.
But you can't just decide to pry that hatch open 4 years later because you think you left something valuable out in the ocean. The moment you break that seal, you flood the entire ship and sink yourself to the bottom.
That is exactly what happens, and the Supreme Court had to unravel her highly technical argument to determine if she had, in fact, breached the agreement. The core question was, is a common law claim for damages like a standard lawsuit a statutory benefit?
And what did they say?
The court firmly said no. They clarified that a statutory benefit refers exclusively to the no-fault compensation scheme. Okay. So we're talking about the basic safety net. Like, if you get hurt at work, the statutory benefit is the system paying your hospital bills and giving you weekly sick pay while you recover, regardless of who was at fault.
Exactly. The right to sue your employer for negligence, on the other hand, is a common law right that has existed for centuries. The modern statute might put rules around how you sue, but the statute doesn't create the right to sue.
Right.
Therefore, her negligence lawsuit was not a protected statutory benefit.
Meaning her clever legal loophole just completely collapsed. The original settlement she signed in 2017 was completely valid and binding.
Yep. The court acknowledged that perhaps, with the benefit of hindsight, she felt she made a bad bargain by settling a severe sexual harassment claim for only $30,000.
Which is understandable.
It is understandable, but feeling regret does not allow you to rewrite the clear, unambiguous words of a contract you willingly signed. The release clause, her promise to drop the matter forever, was the entire reason the firm agreed to pay her the $30,000 in the first place. And the consequence for trying to pry open that submarine hatch was devastating.
Yeah.
Because she breached the settlement by filing the lawsuit, the court triggered that indemnity clause we talked about.
Right.
She was ordered to pay the law firm's legal costs for the entire 4-year litigation on a, quote, full solicitor-client basis.
And we really need to underline how severe that penalty is. Normally, if you lose a case and are ordered to pay the other side's costs, it is assessed on a standard court scale. You might end up reimbursing 50 or 60% of their actual legal bill.
Okay.
But an order for costs on an indemnity basis or a full solicitor-client basis is an entirely different animal.
Sounds expensive.
It means the court is essentially ordering you to reimburse almost every single dollar the firm was billed by their private lawyers. It is a punitive measure designed to punish conduct the court finds completely unreasonable.
Wow. Which means she likely owed a staggering amount of money, almost certainly dwarfing the original $30,000 she received back in 2017.
Without a doubt. What stands out to you about how permanent these legal signatures truly are? I mean, there is a total lack of sentimentality in contract law.
Yeah, the court doesn't care about feelings.
Not at all. You can have a genuinely traumatic underlying experience, and sexual harassment is profoundly traumatic. But once you reduce that grievance to a commercial settlement and sign a deed, the emotional context is stripped away. You are bound by the ink on the page.
It's harsh, but it's the reality.
It highlights the absolute necessity of having clear, objective advice before you sign anything. You need someone to look you in the eye and say, if you take this money, this door is closed forever. Are you absolutely sure?
So what does this all mean?
Good question.
We have looked at the baseline of complex rights employees possess. We have seen a record multi-million-dollar victory turn into a catastrophic $10 million debt because of a stubborn refusal to settle.
Yeah.
And we've seen a worker slammed with massive punitive legal bills for trying to use technicalities to undo a settlement she had already agreed to.
It's a lot to take in.
It is. The core lesson we can pull from these case studies is this. The Australian workplace relations system absolutely offers essential protections. There are powerful legal mechanisms designed to fight unfair dismissal, harassment, and discrimination.
Thankfully, yes.
But the legal framework surrounding these protections is a double-edged sword. It is deeply, coldly unforgiving of hubris, stubbornness, or attempts to rewrite history.
Perfectly said.
Whether you're an employee facing a genuinely toxic workplace or a manager trying to handle a complex dispute, the lesson is exactly the same. You have to seek specialized, objective guidance early.
Early is key.
You need someone who isn't emotionally invested in your sense of justice to look at the board and tell you what your actual statistical odds are. You have to know when to press your advantage, but more importantly, you have to know when to take the deal and walk away. Justice in the employment sphere isn't just about the moral high ground of being right. It is fundamentally about being pragmatic.
It is entirely about risk management, and looking at these rulings actually leaves us with a rather unsettling dynamic to consider.
Ooh, what's that?
Well, in both of our deep dive case studies today, the employee who lost was hit with a ruinous cost order to pay the employer's legal fees. That is the loser pays system in action, and its intended purpose is to stop frivolous lawsuits from clogging up the courts.
Right, which makes sense on paper.
On paper, sure.
Yeah.
But we have to ask the broader question. Does this system inadvertently create a massive chilling effect? If the penalty for failing to perfectly execute a complex legal strategy or making a miscalculation during negotiations means potentially paying millions in your former employer's private legal costs, could the sheer terror of financial ruin be forcing everyday, genuine victims into staying silent about severe workplace abuse?
Wow, that is a heavy, very real question to leave you with, and it definitely complicates that clean Hollywood narrative we started with. Thank you for joining us on this deep dive. Keep questioning the systems around you, and we will see you next time.